location.
All right, let me pause you for a moment. Members of the jury, I need you to go into the jury room, please. Agent Blythe, I'm going to ask that you step outside the courtroom. Everyone may be seated.
Yes, ma'am.
Mr. Fernandez needs to go in the back. I need Miss Bridegan to step up, Mr. Clifton to step up, and get Kirsten Nelson on the phone. On Zoom, switch over. If the state would clear the way so they can have a seat. Do you want to call your appellate counsel? They can join via Zoom. Ms. Bridegan, you can sit down. It's okay. Print a copy of the order.
If you go into Zoom and put in that number, it should come up. Like that's the meeting.
Are the attorneys from the Gardner firm on Zoom?
Good morning, Your Honor. Kirsten Nelson on behalf of Ms. Gardner. I believe Jose Baez and Ron Sullivan are also present.
All right.
Yes, Your Honor.
Okay. Good morning. Is Mr. who's represent Sam Solario?
Sam, you can hear us. Could you just announce your presence?
I can hear you fine. I'm not visible because I'm unsuitably attired for court, Your Honor, and
Yes.
I didn't want to appear poorly.
Yes, sir. I appreciate that. Thank you. So, Mr. Clifton, for purposes of this hearing, I received, while I'm in the middle of the trial of the state of Florida versus Mario Fernandez Saldana, I received an email indicating that Ms. Bridegan is refusing to comply with the court order. Is that correct?
Yes, Your Honor.
All right. And then Ms. Nelson is the person that notified the court. So, Ms. Nelson, I'll hear from you.
Thank you, Your Honor. I also apologize. I am not suitably attired for court, so I will keep my camera off. We are moving for a motion, or our motion is for an order to show cause why Ms. Bridegan should not be held in contempt for failure to comply with the court's August 11th order, as well as the order this morning and the order yesterday.
Ms. Nelson, do you agree that it would be indirect contempt of court?
Yes, Your Honor.
Mr. Clifton, do you understand the nature of the motion for an order to show cause?
Yes, Your Honor.
All right. So it is basically non-compliance with the court's order that was entered in on August 11th. And for the record, the court had a hearing that was requested based on the subpoenas that were issued pursuant to a prior order. The court heard the objection of the party, the non-party. I then, after that hearing and after consideration of the side that was presented during the objection, the court overruled the objection and issued an order of compliance because it was not being complied with. That is the prior order. Then this morning at approximately 7:19, this court got notice that Ms. Bridegan wanted, well, counsel filed a petition for all writs. The 5th District Court of Appeal has docketed now the appellate process, which is the appropriate way to go if there is disagreement with the court's decision. In the trial court, I believe it was you, Mr. Clifton, that filed the motion to stay this morning. It was approximately, I think, about 8:15 or 8:20,
About
maybe.
20 p.m. last night, Your Honor. But
It was 10:20. I didn't get notice of it until early this morning.
Yep.
Then defense counsel filed a response. The court then issued another order denying the stay and denied it within, I believe it was about 8:30ish, giving Ms. Bridegan 30 minutes to comply with the court's order. Additionally, in the prior hearing, in the prior order, the defense has gone through the expense of asking and paying for an expert to come up to take possession of the phone to comply with the court's order and then return the phone to Ms. Bridegan in short order so that she could have her phone basically selectively downloaded and then returned to her so that there would be as little time away from her phone as possible. And so that is what is not being complied with. Do you believe that this is sufficient notice, or I can write the order to show cause? I'm going to grant the order to show cause, and I can write down date and time. Pursuant to the rule, I believe that you are entitled to reasonable time to prepare a defense for Ms. Bridegan.
we would want reasonable time to prepare a defense.
All right. And I hope that this is not to wait out whether the 5th District Court of Appeal is somehow going to stay. But I will give you, right now, I stopped the trial at exactly 9:30. What do you believe reasonable time would be, Mr. Clifton, for you to be prepared for the defense of an order to show cause for noncompliance, which is indirect criminal contempt of this court?
Your Honor, looking to do this today?
Yes. Because the expert drove up today, and so I don't...
I understand, Your Honor.
Okay.
2 hours?
Can we...
And we have a lunch coming up at some point, 12:30?
Yes, sir. Yes, sir. I will, if you require, I will. I will have something written up and filed for you to answer to. If I can get it probably by 10:15, and then I would have the hearing, I would say at 12:30. Is that reasonable?
Yes, ma'am. That would help.
Yes, sir. All right. And whatever counsel, if you all could get in, do you want Ms. Gardner transported?
No, Your Honor, we'll waive her presence. Thank you.
All right. I will see you all again at 12:30 for this hearing, okay?
Thank you, Your Honor.
All right. Thank you.
Thank you.
It goes without being said, Ms. Bridegan, you need to be present again, okay? Go get the jury to get back ready as soon as.
Transcripts. Can someone read back to me the last question I asked?
You got
I'll pay you.
Can you have a read back, please? Hold the jury.
You don't have to say maybe because you did the correction in Mr. Tennant's process that you used at 2 o'clock on the GA location of Mr. Tenon with new directors to look at outside. You used wrong contact and the source of the GPS at 2 o'clock. So all I'm saying is I don't know if it's connected to Mario Fernandez Wi-Fi, but there's enough Wi-Fi access to come surrounding it. Because of the state of the Wi-Fi being located.
Okay. Thank you, Madam Court Reporter. Thank you, Your Honor.
You're welcome. They can come in if they're ready.
Your Honor, the jurors are in the courtroom.
Thank you. All right, welcome back in, members of the jury. Everyone may be seated. Mr. Dreiser, if I could just interrupt you for a couple more seconds. Members of the jury, I want to apologize for the interruption. I want to make sure that you all understand that the interruption has nothing to do with either the state or the defendant in this case. Instead, I had an emergency issue that I needed to resolve prior to you all continuing because it's time sensitive. And so I apologize for any interruption. I believe that we're back on track. So if you thought anything, you should disregard anything. It was my issue, not the attorney's. Does everyone understand that? If you could answer out loud.
Yes.
Perfect. Let's go.
All right. We're back.
Yes, sir.
Okay. Thanks for being here. We're now on January 20th.